Welcome, everyone. I'm about to introduce Lynne Bulldock. She's a fantastic lawyer, and I also lay claim to the fact that she's SNN's attorney. So that's, incestuous, but who's looking? So one of the things about needing a lawyer is, you know when you need it. That's the key. You can go 6 months and all of a sudden you need a lawyer, you have to find a lawyer. And the trick is to find the right lawyer. A lot of times you go through more than one. So what we've done is we've selected from the best of the best, starting with Lynne Bulldock. Ladies and gentlemen, Lynne Bulldock.
Good afternoon. Welcome to Trending Legal Topics. I'm Lynne Bulldock, partner of the law firm of FitzGerald, Kreditor, Bolduc in Risborough, with offices in Los Angeles and Orange County, California. I got my start in the financing world, working in-house legal and compliance at investment banks, where I learned from the inside what investment banks and investors want to see in a company and how to structure deals that sell. I'm now the chairperson of my firm's securities department, where we specialize in making financing transactions as simple as possible, if that's possible. We represent startups through public companies in all stages of their growth and development, sort of like outside in-house counsel. Because of my backgrounds, we represent investors, investment banks, and funds of all types in their transactions. We represent startups through public companies, primarily focusing on private offerings and public offerings. My firm is a full-service business law firm, handling everything businesses and their owners may need, including litigation, real estate, tax, and succession planning. Personally, I serve as expert witness on securities law cases and sit on the boards of directors of private and public companies. Now, introducing our panelists. Starting from my left, we have Jon Uretsky. Jon has been one of the few litigators specializing in the microcap space for over 2 decades now. He began his career representing the broker-dealers of the 1990s, spawned from the Wolf of Wall Street. And when those brokers transitioned to working with public companies, Jon transitioned with them. Jon now heads PULLP, known as the MicroCap litigators. Next, we have Alixe McLean, a partner and chair of the Securities and Capital Markets Group at Harter, Secrest, and Emery, a full-service 120-plus attorney law firm based in New York. Alixe is Chambers registered, and his practice is focused on representing public companies of all sizes with compliance with federal securities law, listing standards, corporate governance, and mergers and acquisitions. Alixe also assists investment banks and small to microcap issuers to access the capital markets with a special emphasis on uplisting transactions. Next, we have Richard Friedman, a partner in the corporate department at Sheppard, Mullin, Richter, and Hampton. Richard co-heads the Capital Markets Group and is a member of the firm's blockchain and fintech and ESG teams. His practice primarily focuses on corporate and securities law, with a concentration on public offerings and private placements. His experience includes IPOs and SPACs, domestic and foreign reverse mergers, secured and unsecured private equity financing transactions, registered direct and shelf offerings. He represents issuers and underwriters in a wide variety of industries, ranging from tech to biotech, and including emerging sectors such as digital securities and cannabis. We have, at the end of our table, Alixe Cormick. She has over 25 years of experience in cross-border securities law. She has listed over 150 companies on stock exchanges in Canada, the US, and the UK. She's located in Vancouver, British Columbia, and is going to discuss today changes companies doing business in Canada should be aware of. Jon, let's kick it off with you. I understand there's a significant regulatory shift happening in the microcap industry right now, that will likely change the way the industry is financed. Can you tell us about that?
Yes, actually, for those of you who read MicroCap Review, it's a fantastic publication, by the way. I wrote the legal corner in that, and it was a couple of months ago, and the title of that article was that there were vast changes that were coming to the structure of microcap financing, and those changes are officially here. The SEC, to summarize, just proposed to broaden what it considers to be called dealer activity. And that means that the liquidity providing role that the SEC believes is an activity that ought to be brought under regulation needs to be regulated by rule. So not to be the bearer of bad news, but as most of you can imagine, that's going to be problematic for those in the microcap industry that are the lenders on the lending side.
Jon, can the SEC unilaterally do that, and how will it affect the microcap industry?
Yeah, so that's a problem. It is really problematic. They can kind of do whatever they want. I heard that. You're right. So the problem is how they do that. What happens is they do have the authority. They've never done this before. This trader exception has existed effectively since there was a 34 Act nearly 100 years ago. And no one ever thought that there was a problem with it. And it was only since COVID that they began to bring enforcement cases about that. Now, we defend a lot of this activity. We always said you shouldn't do regulation by enforcement, create a rule, you're the SEC. And unfortunately, that's exactly what they just did. They are creating a rule. What we would predict from this, and we're working with a lot of our clients on dealing with this, is there's an exception that is likely to be a part of it for under 50 million. So if you work with convertible debt lenders, they probably do have net worths larger than that. They can try to fall under that exception. A lot of our other clients are working to find areas overseas. Either way, this probably won't go into effect for about 1 year from now. And we are looking forward to working with our current clients and anyone else on all the complicated issues that will no doubt arise as a result of this proposal. I'm sure, though, that the microcap industry will adjust. I've seen it do it before.
It's going to change also 144 opinions, because those lenders, they need to get Rule 144 opinions to have the restrictive legends removed from their shares once they convert their debt. And very few law firms are doing those now because of the risk involved, because of what you said, Jon.
Yeah, you're right.
Alixe, will you please update us on the latest in board diversity initiatives?
It's always an exciting topic, but with board diversity initiatives, there's been kind of three primary approaches that have happened. There's been private ordering, that's institutional investors, perhaps some folks in this audience, applying pressure to public companies to diversify their boards. And that's already started to happen, particularly as you look at some of the larger public companies. But you also have states being active. You have about a dozen states who are in process of either adopting laws or have adopted laws to require or in some ways encourage companies to have more diverse boards. And you have kind of two examples of that. You have a prescriptive approach, which is a you do it or else kind of approach, and then there's the shaming approach, which is you have to tell everybody in the world what you did, and why you don't have a diverse board. Since I came out west this morning, I thought we'd start by talking a little bit about California. So California in 2020 passed a rule that required California companies to have one underrepresented group on their board. So either a person of color or someone from the LGBTQ plus community. That rule was recently struck down just last month by the California courts, arguing, on the argument that it violated the Equal Protection Clause because it required quotas. So that's kind of put a little bit of doubt on some other states' laws, like the California's neighbors to the north, Oregon, had a similar law, and there's open questions about whether that will withstand scrutiny or not. There's also an earlier 2018 California law that required gender diversity on boards and for boards to have at least one female director. And the market has kind of reacted to that. We've seen a lot more diversity on those boards. But now there's some question about whether that law will withstand scrutiny or not.
Jon, what about NASDAQ? I'm sorry, Alex, what about NASDAQ? Didn't they also put in a proposal?
Yeah, so NASDAQ has, they've taken the shaming approach as opposed to the fining and penalizing approach. So public shaming, and the way that works is you have to publicly disclose either in your proxy statement or you have to upload it to your website, a matrix that discloses the racial makeup of your board, the gender of your board members, and if anyone identifies as LGBTQ plus. And coming up in the future will be a requirement that if you do not have one of specific categories of directors on your boards, you're going to have to publicly disclose in your proxy statement that you don't have diverse board members and why you don't. So kind of more of the public shaming approach to the issue. And what I find most fascinating is the NYSE hasn't followed. Usually they act in lockstep together, but they haven't on this particular issue. I'm not sure if that will change, but so far the NYSE hasn't taken action.
I'm actually on a committee, the Octane Women on Boards Committee, and there's an online registry for companies that need to get women in diverse boards of directors. So it sort of spawned this little industry of these board directories online too. So if any companies do need that, that is available. And I know that NASDAQ also has some references to registries for boards of diversity. Richard? Will you update us on the latest developments that you're seeing in your practice?
So my update's going to be an alphabet soup of updates that covers not just regulation, but enforcement, like Jonathan talks about. So a lot of what we see is coming around by enforcement as well. I'm going to start with SPACs. So everybody's familiar with SPACs, the run-up in SPACs. But the de-SPAC side, which has a big backlog on, the SEC in March put out proposed regulations that's going to require, in a de-SPAC, making the target like a co-registrant. So the target's going to have to now certify and sign off on the S4 the same way the public SPAC has always signed off. Why? Because they want to put more people in harm's way or make them think that they have to certify things. And then there's going to be other parts of it where SPACs were doing reverse mergers so that the target could put out projections so that the public could, or the investors could invest on the pipes. Well, they were using the projections under an exemption that existed at the time, which was different than an IPO, which doesn't allow for those kind of exemptions. And so now they're trying to tighten the rules and make any of the projections or any of the other information that the de-SPAC target's using to go out and try to raise funds subject to the same rules like an IPO. So again, the SEC's tightening it, trying to keep everybody on a much less tighter leash and not give them as much flexibility when they're going out trying to raise money for the de-SPAC or the pipe that goes with the de-SPAC. And so that proposed rule is going to provide enhanced disclosures with respect to SPAC sponsors, conflict of interest, dilution, projections, and fairness of de-SPAC transactions. The short of it is de-SPACs are getting harder. What we're seeing is that investors, the SPAC investors are tending to almost all redeem at this point. They're waiting to see if the stock price goes up in connection with the announcement, but generally they're all redeeming. And the financing that's available, if at all, on the other side of the de-SPAC, while initially it used to be equity financings and everything seemed good, has turned into some other kind of convertible financing that now has floors because there has to be a floor for NASDAQ purpose, or it may be equity because it's got to count for NASDAQ listing purposes, but it may in the future reprice on certain dates. And so the financings that are happening in connection with SPACs have changed dramatically over time, is what I think I'd say. Another trend I'm seeing is regarding the digital securities space. That's a very broad space. I'll try to define it a little bit because there's a lot of confusion. A couple of years ago, maybe a little bit more, pre-COVID, it started with these ICOs. And so people were selling things called safes that converted into what would have been a token offering, which was a digital security. Flash forward beyond ICOs, which the SEC, the most famous one would have been Telegram, which raised $4 billion. Well, they did everything perfectly. They did a private placement to accredited investors, sold that, probably raised more money, did that, and then when they were on the cusp of launching their digital security, the SEC said no. Why? Because what you'll find in this space, the innovators, the financial technical people are racing far ahead of the SEC in regulation. And so they're able to do things, but the SEC hasn't figured out how to regulate it. And so in Telegram's case, at the end of the day, they gave back all the money and scrapped what they were going to do, $4 billion worth of money. They had Skadden working on it. You're talking about top law firms, everything was done right, but it didn't matter if the SEC wants to regulate, they regulate. Flash forward beyond that, so there's all kinds of cryptocurrency. I'm not going to get into that. I view that very differently. That's currency, which is like legal tender. It's Bitcoin and it's Ethereum. It's the only two things we know that are actually currency. You may buy, sell, trade a lot of other currencies, but the SEC hasn't said that those are not securities right now. And beyond that, the most current thing I'm seeing is NFTs. So now something else. It's a digital token, which is a representation of many things that you'd think. It's like baseball cards or like artwork, and all it is a representation that you own it. Now, I'm using the word own. You don't own it. And that's really important for people to understand. Anybody who's buying an NFT or thinks they're buying an NFT is not buying something they own. All you've done is pay for a right to use that representation. It's actually a license. And so people should understand that. I don't think they do. I'm currently working on 2 public offerings that are gaming companies that intend to what's called mint NFTs within the game. And so it's an avatar, maybe it's a skin, maybe it's something that you'll wear or use when you're playing a game. It's something that has utility, a function. The one thing about all this stuff is whether it's a token, whatever, or an NFT, there's an argument about whether or not it's a security. That's the whole thing involved here, which is why you need securities lawyers. But the point is that if it truly has a utility, if there's a reason to use it, and it's not sharing in profits or doing other things or things like that, it may be valid. You may be able to sell it and buy it. Otherwise, what you're going to find out later on is the SEC is coming and regulating, and they're doing it by enforcement in that space as well. The last area I'm going to touch upon, one more acronym, ESG. This is as broad as it gets. And it's environmental, social, and diversity. I'm sorry. And the SEC literally came out with something again. Oh, and I skipped one thing. Sorry, I'm going to go back and say one thing, which is the SEC doubled their task force yesterday on the cybersecurity side. It was an announcement they made. I forgot to mention that. ESG disclosures, there's a proposal that came out in March to enhance standardized disclosure regarding climate-related risks and opportunities. And so this proposal is going to require public companies to disclose climate-related information in registration statements and annual reports, not just for new offerings, but for existing public companies. And it's going to require governance, and it's going to cover areas of governance and oversight, climate-related risks and impacts on strategy, business model, and outlook, risk management, GHG emissions, and it's going to require attestation of emissions disclosure, as well as climate-related targets, goals, and transitions. And so what they're after is greenhouse gas emissions, whether it's a primary thing that you emit in your business, it's a secondary thing that you use in your business, or it's a tertiary thing that your business impacts with third parties. There's going to be required disclosure in your filings, not only narratively, but in your financial statements as well. And so if you haven't figured out that being public is a really expensive thing in the first place, the SEC is trying to pile it on and give you more things to worry about. And you're going to have to go out and hire third-party providers, whether it's the accountants have to do more work to figure out how it impacts the financial statements or what you're doing, or you have to hire a third-party service provider to come in and help you analyze your greenhouse gas emissions and certify as to what they are in connection with your filings. I think I've said enough of all the things, so.
I did have one question though. The matters that you're talking about, do they just apply to public companies or public and private?
So the rules that I'm talking about apply to both, but not in all cases. SPACs is obviously private and public. That's a going public target company. NFTs It's both, because at the end of the day, it's what is a security. So fundamental SEC Section 5, anytime you issue a security in the United States since 1933 and 34, it either has to be registered or exempt. Doesn't apply that way in the rest of the world except Canada, which I think has a 4-month in the day rule. And so we have a 1-year holding period for restricted securities. The rest of the world doesn't have it. So many of the things I talk about, when it's EFTs or tokens or coins, they're happening, and they're happening in Europe, and they're happening out of Switzerland, they're happening internationally. That could be privately, but they may be regulated when you sell them to investors in the US. And then the last part, the ESG, as much as those regulations apply, the proposals to public companies, it's obviously the most important topic in the world these days. And so both private and public companies are coming up, and you can go to their websites and see it. They have ESG policies now. And so getting advice and guidance on what your ESG policy is yet another emerging area. Thanks.
That reminds me, Alixe, McLean, you talked about board diversity initiatives. Do those apply only to public companies, or public and private? Should private companies be concerned with that?
Private companies just need to pay attention to it. Well, and I should take a step back. All companies should pay attention to it. I mean, having an inclusive board adds value regardless of what a regulator may say. But putting putting that aside, yes, you have to kind of pay attention to state laws. Some state laws, these diversity requirements do apply to private companies. So, for instance, in my home state of New York, we don't have currently a mandatory requirement, but we do have a requirement that the state is studying it. So when you do your annual, if you have a corporation, when you do your annual recertification each year with the tax authority, you now have to disclose the racial and diversity makeup of your board. And it's definitely expected, and there's bills working their way through the legislature to create, for both public and private companies, a diversity requirement in New York, and other states are evaluating it as well. So if you're a private company, it's something you need to pay attention to and understand your own state's law.
I thought it only applied to public, but not so.
Not so.
Thank you. Alixe, what have the Canadian securities regulators been up to in Canada that would be of interest to our audience today?
Well, about 60% of you out in this group that's here today are actually Canadian companies, or listed on a Canadian exchange. And so I wanted to kind of touch on a few things. The Canadian securities regulators have been busy. In April, they came out with 2 new policy initiatives and 1 consultation paper. So the first one concerns primary business. So when the company is going public or it's doing a reverse merger, they have a definition of what is a primary business to dictate what financial statements you're required to have. And oftentimes there's a bit of a debate. So if you're in the process of acquiring a business, or you've just purchased a business in the last 2 years or 3 years, because you need 3 years financial statements, if that's your primary business, you're required to have audited financial statements for those companies and interim statements. And so the question comes up, what if you're doing roll-ups and maybe it's 2-3 companies? So this has been an ongoing issue where people are quite sensitive to. So they've come up with a new rule in terms of changing Rule 41101, which has to do with the companion policy for general prospectus requirements, and they've kind of fleshed it out. The first kind of consultation period was from August to October. They've now fine-tuned it. They came out with it April 7th, saying we've only done minor changes, and now it goes forward. For mining companies in particular, there's a lot of clarity of when a mining acquisition is a property that requires financial statements and when it isn't. So I think that's a good thing. The second initiative has to do with access equals delivery. This one's also positive. So there's a lot of negatives I heard here in the US, but in Canada we do have a couple of positives. So access equals delivery, they've announced that they're going forward with that. They've only got 1 question left. So they've removed kind of proxy requirements, but they've said essentially financial statements, MD&A, both interim and audited, as well as, other materials that, other than materials in and around prospectuses as well, can all be access equals delivery, meaning you post on CDAR and then do a press release saying we posted on CDAR, you can get it there, but if you want a paper copy, contact us here, and that's all you need to do. So they're asking, one question in particular is whether a news release, in particular for venture issuers, is too much requirement in terms of cost as well as just the inconvenience of it when issuing out audited and non-audited financial statements. So what has been removed, and just to make it clear, is that in the initial proposal, they had also put shareholder meeting materials and takeover bids and things like that in that. And they came back and said, you know, that's too shareholder sensitive, so we're not going to go forward with that at this particular time. The second, so the other is a consultation paper for mining companies. If you are in that industry, pay very, very careful attention to this. The proposals, they've got 38 different questions that they're asking the industry. The first part of the read is really kind of a slam against you're not doing your 43-101 reports the way you like, that we like to see them. Qualified persons aren't qualified in terms of education, in terms of being familiar with the mineralogy that they're testing on, and also just PE reports and being used incorrectly, and a whole litany of things that they're just not happy with. But they're also wanting to modernize and saying, like, you know, during COVID, we got questions about people wanting to use a drone rather than having to walk the property. And then if more than one QP is required, do all of those QPs need to walk the properties, or which one doesn't make sense to do that? So they're wanting to kind of look at kind of the technical reports and say, should we modernize against Australia and other jurisdictions that have kind of updated that? So this is something, as I said before, if you're in that industry, you should be paying attention to. Definitely get the report, definitely make comments, or you're going to get changes that you don't want. The other thing I think that people should know about, I think about 38 of the attendees or companies that are presenting here today are listed on the CSE. CSE back in December proposed a number of different changes. It was kind of deceptive. Their press release essentially said, hey, we're going to introduce SPACs in this non-venture issuer category. And what they didn't highlight is there were also going to be changes that would affect all other issuers that are listed on the CSE. And the biggest change, I would say, was for private placements. So in private placements, you're now going to be required to get shareholder approval anytime you create a new control person and 50% of the shares are issued out, or if 100% of the shares are issued out. If you are one of those new category non-venture issuers, those categories move down to 25% if a new control person's created, and 50% if of the share capitalization, shareholder approval will be required. The other is the private placement can no longer close without you doing a press release 7 days in advance of closing. Now most people basically close immediately on issuance of that press release. And also you're going to have to get CSE approval for that press release because they want to make sure that you've complied with these new rules that they put in place. Shareholder approval is also going to be required in acquisitions that you make where the number of securities issued out is 25% of the outstanding shares, or a new related parties involved, and 10% of the shares outstanding are going to be issued in that transaction on a fully diluted basis. And those are significant changes and quite expensive. So there's other changes as well. Also, I just want to mention one thing about non-venture issuers. So that non-venture issuer category is based on kind of an assessment of 4 different points. And if you meet the equity requirement or the net asset requirement or the capitalization requirement, if you meet 2 out of the 4, the CSE staff can declare that you're a non-venture issuer. That means you lose all your status as a venture issuer. So now your audited financial statements and interim statements are due sooner. You lose that 30-day, 15-day advance kind of treatment. Also, you're required to file an AIF, and you don't get a choice about it as you do with the TSX Venture Exchange to decide whether you're moving up or not. There's too many proposed changes to run through there. There's just kind of want to give you a flavor for that. So
That was very comprehensive. Thank you, Alex.
sorry.
We've heard a lot about a lot of different topics. Are there questions about anything?
Is there anything that Canada or the SEC is doing to make things easier?
Well, I think access equals delivery definitely makes things easier, in terms of the financial statements. You don't have to mail them out anymore to people. So that's definitely a bonus. And I also think the business acquisition rules, the definitions now are much clearer, particularly one of the issues with Canada is much like the States. People forget that there's state regulations as well as federal regulations in the United States, but we have a provincial regulatory system. And the provinces on kind of what is, the primary business of a company wasn't settled across different provinces. Were applying it differently. So what they've tried to do is get all on the same page, and that's going to make things easier.
And I would say in the U.S., elections matter, and the current SEC, I don't think has a deregulatory focus right now.
There is some disagreement within the SEC on some of this, especially on the ESG stuff, but not. They're definitely in more of a regulatory environment.
Yeah, and on our side, on the mining reports, as I said, they're now looking at kind of ESG's always been part of that. So to a certain extent, guys in the mining industry and people in Canadian public companies are a little bit ahead of the game because we've had to do that disclosure probably for 20 years now. Just slightly different.
I didn't realize that. We have another question?
Yeah, question for Richter around the climate risk disclosures. I just skimmed the proposal and said the non-accelerated filers would be kind of phased in. Do you have a sense of what that phase-in period looks like? I'm just thinking for the microcap companies, this could be kind of a big financial burden, of being public.
Not for another year plus, so there is time.
Okay.
It's phasing in not till at least 23, I think it is.
Okay.
But right now, it's still out for comment.
Yep.
We're in the 30 or 60-day comment period, so I'm not sure what the final rule is.
Okay.
There's an exemption for the category 3 on smaller reporting issuers, but category 1 and 2 on greenhouse, at some point, they're gonna have to, if it goes through, they're gonna have to comply.
So if it goes through for these microcap companies, it seems like their lawyers are gonna get, the benefit, but they're not
even a
gonna.
lawyer cost. It's a third party. It's a new consulting business that's going to exist. Environmental advisors are going to come in and help you analyze your footprint.
Okay.
That's a couple $100,000. The estimates I've seen from the blogs I've read, it's anywhere from $300,000 to $600,000 a year.
A year?
Yeah.
Oh, that's not good. Hopefully they, something
I wouldn't
changes with
be
that.
surprised if the accounting firms or, I don't know, law firms, whatever, someone's going to develop some other side business. But there's going to be third-party providers who do it.
Yep, thank
There
you.
are a number
Already
of,
do it,
There-
right?
we actually represent one of the environmental consulting companies that does that. You're not going to get much cheaper than that.
And it doesn't matter the size of the company?
It doesn't matter. There's no exemption, at least, that I'm aware of. Yeah.
Wow. Any more questions? John?
It's for Alixe. So my understanding is by 2025, we have to have 2 underrepresented directors. So I got a letter from Kreditor. They became a shareholder, and they said, we need to institute a minority into our board right now. And I said, don't I qualify? They go, no, because they said, you're a founder of the company. You're not classified. So, there is no regulatory. But if I put 2 women on my board, it should satisfy 2025.
Well, it depends a little bit, and you're correct, because institutional investors, like I said, there's private ordering, so they can say what, they have the money, they say whatever they want to say, and they can have their own priorities. With the NASDAQ requirement, you have to kind of look at, both to have gender diversity and also either racial or someone from an underrepresented minority group. So you do kind of have to look at both.
Well, I think I qualify for that.
I'm not going to make judgment calls on that one, but
It's made for interesting D&O questionnaires. And
Yeah,
questions
yeah.
that are asked.
I qualify.
Let me just say one thing about kind of the gender diversity. So Canada proposed something in 2017, and it's been sitting on the shelf since then. And the expectation is, one, the regulators in Canada are taking the view of looking to see if the industry will regulate itself. And to a certain extent, they have. And they're very aware, like Canada's a little bit different. Like my particular province, I think about 50% of the public companies come from there. About 50% of the world's capital in mining comes from Canada. And I think everyone can acknowledge that. But they're looking at, does it make sense, to kind of force people in certain industries to put someone with a gender or other kind of diversity issue on the board. At the same time, diversity can kind of increase the board's, I guess, knowledge base. I had a talk with someone who's listed on NASDAQ. They're based out of Vancouver last week. And I'm looking at their website, and they basically say we're about community values, we represent blah, blah, blah. They're all white males on the board with Ivy League educations. They don't represent their community at all. And the product that they're aimed at and industry that they're aimed at is not them. It's not the white males from Harvard and Princeton.
So that's similar to ESG. The SEC is coming in and regulating, telling people, as opposed to shareholders or industry, where it really should be coming from. I mean, that's
And
the
industry
one.
was making some efforts there too.
The change on the institutional side, like it's really hard. Like I wish we could have a proper debate rather than just pushing out the trends. But the change really, like for me, I've been a lawyer for over 28 years now, and so when I first came into law school, that was an area of interest of mine in particular. But at that particular time, institutional investors were doing about 3 to 2% investment, looking at ESG issues. ESG is not a new term; it's been around since the 50s. But at that time, there wasn't that much interest. But institutional investors now, 70% of them say that they take a look at that. They think that it's going to be up to 90% within 5 years as being a factor of whether they invest in you or not. And certainly for myself, like I'm very active in a number of different areas, but this is something that gets asked all the time is, what is the composition made of?
I can say one thing, the people on this panel are never bored. That was a wealth of information. Thank you so much.
During COVID, while we were all at home watching TV,
Is that what we were doing?
there was a delisting of all of these pink sheet companies that were listed at one point on OTC. I haven't heard anything about it in the last 6 months. What was the outcome? What was the relevation? I know it's not something that you all talked about, but let's face facts. There were thousands of public companies that no longer are quotable. So please help me, help the audience. What happened?
I don't know if that's an answer to that. They all got delisted, and what's left in the wreckage is OTC Markets picked up the mantle. And if you want to get listed now, you go to OTC. FINRA's been moved to the side on part of it. And then the only other thing I'll add is one more yet industry regulating itself is, has anybody tried to do a corporate action? Whether it's a reverse split, change your name, move from Texas to Delaware, which maybe somebody wants to, 6 months at a minimum, and they're lucky if they call you back. And that's what we've been experiencing.
What the OTC did is OTC about 2 years ago started notifying issuers that they were going to make certain requirements in terms of having certain disclosure available. So what they've done is essentially, this is kind of like a long-term, Cromwell's been kind of looking for a long time to kind of elevate himself to an exchange for the OTC markets, and it's been kind of step by step. So he's wanted that recognition for quite some time. But one of the things is the pink sheet companies that were listed, a lot of them weren't doing any disclosure whatsoever. So they were just not even abiding by the spirit of what was required, which is having their financial statements and current information available. So he then said, or the OTC markets then said, well, we're going to make it a requirement that you have to have that current information. We're going to give you a period of time to do it, and then we're going to let you know whether you have it or not. And so people were given till September of last year to have all that information in place, and if they didn't, they were taken off. In the rush for people to kind of bring their information up to date and current, the OTC markets is behind, so people still have skull and crossbones because they haven't gotten to review kind of their financial information and the things that they have there. A lot of Canadian companies, because we have a relationship with the TSX Venture Exchange in particular and the CSE, they automatically recognize Canadian companies, although a lot of Canadian companies got those OTC letters as well.
We recognize certain exchanges and allows companies from Canada to come list a
Yeah,
little
'cause
bit easier.
So there's 15C to 11 that basically essentially requires that certain information be available. And it used to be back in the day, again, I've been around for 28 years. So back in the day, you actually used to have to file all your documents for Canada with the SEC. They stopped that probably, I don't know, 20 years ago, not quite 20 years ago, probably 15 years ago, where it was automatically you were recognized if you had filings on CDAR, which is where Canadians filed it's our version of EDGAR, to simplify it.
And if you're pink, like she said, and you're not current, they'll give you an opportunity to get current. It's a little bit different than if you're pink trying to apply to OTC to go up. If you get rejected there, I don't know what you experience, they'll tell you you can't reapply for 6 months. And then 6 months later, you can start again.
What some that we've seen have done is actually just decide that the North American climate is not favorable to them entirely. It's getting more and more burdensome, more and more expensive. We see a lot, including some that you're talking about, that have decided to actually list on the UK exchange instead. And they just think that overall, that initial expense is worth it because the regulatory burden and financing, it's just so much more friendly than it is in the US and Canada.
There's no liquidity.
Is that the AIM market?
Ames market.
AIM?
Yes, yes.
But there's no liquidity.
There's no liquidity.
I didn't say it was smart, I said that's what they're doing.
I got a question in general. From a legal's perspective, does anyone in the panel want to make any comments about some of the Chinese legal issues in the companies that we buy and sell?
One more
Is that too big
area.
of a
One more
subject?
area of
Too
regulation.
big of a subject?
No, at the moment, there's two parts going on. One is the accounting part. Sorry, I'm not close. The accounting part where the SEC is trying to implement rules and get so that auditors who audit Chinese companies can open their books and the SEC can see it. And the other part is they're enforcing by comment in the process. No, there's been only one Chinese public offering in the last, I don't know how many months. How that one got through, I'm not 100% sure. We all ask, but there's others that are stuck in comment right now, and it's all, when you see the next coming of it, if you've seen any of these covers that now have all the VIE and all kinds of other disclosure, it's a 3-page cover that tells you all the risks of investing in China, and you don't really own what you own. You own a company in Cayman or BVI that owns an interest in a company in Hong Kong that actually has contracts to maybe own a company in China if it could ever own it. It's what we've always known, but now it's on the cover.
Yeah.
It's actually
That's-
worse than being in comment, because a lot of them are through comments.
And they're still stuck. And the one other thing I'll add is, on the last day of Trump's presidency, he signed a proclamation, I don't know how many of you came across it or not, that listed a bunch of Chinese companies that basically were on a bad list that got delisted from NASDAQ because they were companies that we couldn't do business with for various industries. Some got caught in all-encompassing, some got out of it that I know of. And then that hasn't quite worked its way out yet, so that's part of it.
And it really affected the tech industry in particular because a lot of the companies that were on that list, 2 of them provide most of the kind of core pieces of things for things like your telephone and other types of tech.
We'll all be here throughout the remainder of the conference for further questions. Thank you for your attendance.